Andarki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on Order 22 Rule 3 of the Civil Procedure Code, in which Honorable Madhya Pradesh High Court held that the presiding officer or the junior civil judge has no basic knowledge of the CPC. She has to be sent to the Judicial Academy for training. Why? Refusing to substitute legal representatives of the plaintiff. Refusing to substitute the legal representatives. You know, in the CPC, since we are telling the young students, latest batch, if the right to sue survives, the representatives can continue. If it is a criminal case, we can't do anything. Suppose A committed the murder of B. During the trial, A dies. What happens? Nothing. The case stands abated. But A gave a loan of 10 lakhs to B. He has instituted a civil suit. In the meanwhile, he died. When it is having a right to sue, his legal representatives can continue the same. This is the basic knowledge. I don't know what happened to that concerned judicial officer. Justice Hirdesh of Madhya Pradesh High Court, in the case of Presiding Pathak versus Nathuram. This is miscellaneous petition number 440 by 2025 on 29th August 2025, held that the civil court committed an error in dismissing the application to substitute the LRs. Now they have allowed the plaintiff's impleadment as a substitute, or as now he can continue as the original plaintiff as per Order 22 Rule 33, that is substitution of the parties or legal representatives. Actually, this Presiding Pathak, he filed a writ petition under Article 227 of the Constitution of India. Now, as far as the facts of the case are concerned, please remember, there is one person by name Kundal Lal. He is the grandfather of Presiding Pathak. Kundal Lal, actually, he is having some land in Bhim Basti or something in Delhi. He is having some Bhim Basti in Delhi, some land, maybe agricultural land or a land set. And actually, his daughter, who is the mother of the plaintiff, his daughter, she filed a case claiming her 1/3 share. Because actually she has claimed part of the property, the quite common మనకి అయిపోయిన తర్వాత ఈ ప్రాపర్టీలో she has written a will in the name of Presiding Pathak and some others. She has written a will in the name of some others. So regarding all movable properties and immovable properties in favor of Presiding Pathak. Right? After her death, the present petitioner, Presiding Pathak, her son, he filed an application with death memo for impleadment of the case. ఆ కేసు ఇంకా ఫాదర్ మీద 1/3 షేర్ కాలేదు, డిస్ప్యూట్లో ఉంది. Since he has got a bill written in his name, he filed the case to substitute him in the legal representative కింద పెట్టాడు. But the court did not allow. ఎందుకు? ఇది కూడా మనం తెలుసుకోవాలి. లోవర్ సివిల్ కోర్ట్ did not allow. ఎందుకంటే because there are some other relatives, legal representatives, ఇంకా లీగలైజ్ ఇంకా అతనికి బ్రదర్స్ వాళ్ళు ఉన్నారు. మరి వాళ్ళు కూడా ఇంప్లీట్ చేయాలి కదా. నువ్వు అక్కడవే చేస్తే ఎట్లా? వీడేమంటాడు, నాకు వీలునామా ఉంది కాబట్టి నన్ను ఇంప్లీట్ చేయండి. మిగతా వాళ్ళు అడగట్లేదు. ఇన్ వాట్ వే ఐఎమ్ కన్సర్న్. నో యూ హ్యావ్ టు ఇంప్లాల్ ఆల్ దీస్ పర్సన్స్ అని చెప్పి లోవర్ కోర్ట్ దే హ్యావ్ రిజెక్టెడ్ ది అప్లికేషన్. యాజ్ సచ్ హీ హ్యాస్ come to the Honorable High Court of Madhya Pradesh. Now, what are the findings or analysis of the High Court? It was found that the civil court rejected on the ground that there were some other LRs apart from the plaintiff in the will. Who is LR? Yesterday or tomorrow I am going to tell you. Section 2, clause 11. So simply, legal representative is a person representing the estate of the deceased in law. Representing in law. Maybe executor, maybe administrator, maybe GP holder, maybe relative. So many persons are there. So therefore, very famous case law, Shakuntala Devi versus Shatrughan, in which it was held that the holder of the will may be substituted as the original plaintiff. So, Order 22, Rule 3, if you want to allow the person, there is no necessary for any inquiry once the death memo is filed. And even the court did not come to the conclusion, or the other parties, the respondent or defendant also, did not claim that the will is a forged one. ఏదైనా ఫోర్జరీ వన్ అంటే దాని మీద చాలా గందరగోళం, అది కూడా కాల. సో ఇట్ ఈస్ నాట్ అబ్టైన్డ్ బై ఫ్రాడ్, ఇట్ ఈస్ నాట్ అబ్టైన్డ్ బై కొల్యూషన్ ఆర్ కోయర్షన్, ఇవన్నీ చెప్పుకోవచ్చు. ఇవన్నీ లేవు. సో దేర్ ఫోర్ ది సివిల్ కోర్ట్ షుడ్ హ్యావ్ యాడెడ్ హిమ్ యాజ్ ఎ పార్టీ. సో ఇట్స్ అ మేనిఫెస్ట్ ఎర్రర్ ఆన్ ది పార్ట్ ఆఫ్ ద సివిల్ కోర్ట్, బట్ it shows that the presiding officer, she is a lady, has no basic knowledge about the civil procedure code. So therefore, she needs training. She has to be sent to Judicial Academy for training. Anyway, ఇంకా నయం ఆవిడ మీద ఛార్జెస్ ఫ్రేమ్ చేయమలేదు, కొంతవరకు నయం. Anyway, this is a good lesson for the judges also. You must be thorough with the CPC, otherwise such problems will come. So read the case law and enrich your legal knowledge. I am stopping here. Thank you very much.